IVM.
I want to thank Intel for supporting our show. Do you remember last year when we spoke about how the Intel vPro platform is built for business? Well, I'm glad to say we've kicked it up a notch. That's right, Intel is back with a new and improved version of the platform. The new Intel vPro platform lets you do more of what you want and less of what you don't. So it's better for you and for your IT teams, who really are the backbone of keeping your work-from-home experience easy and enjoyable. I can safely say that the new vPro platform gives you more enterprise efficiency with less constraints. Visit intel.in/morewithvpro, that's VPRO, to discover how you can get more done with less waiting. If you're listening on the IVM Podcast Android app, click the link that's visible to you now.
Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. Over the last few months, we've seen the Supreme Courts and state high courts, as well as trial courts across the country, engaging in some pretty remarkable judgments, to say the least. To discuss this with us today, we have Alok Prasanna Kumar, who's the Senior Resident Fellow and runs the Bangalore office of the Vidhi Centre for Legal Policy. Welcome, Alok.
Thanks, Anirudh.
So what we'd like to ask you first, Alok, is we'd like to understand constitutionally, what is the role of the judiciary in India supposed to be? Now, all of us learn in civics class that it's supposed to be one of the three pillars of government alongside the legislature and the executive. But in practice, is that really how the judiciary in India operates? What is it actually supposed to do?
So this is a difficult question to answer very simply, but let me try and break it down as simply as possible.
Sure.
When we say the judiciary, we mean all the three layers. The three layers of the Indian judiciary are your trial courts, which is the district level, high courts at the state level, and the Supreme Court at the national level. All three of them have a constitutional role, by the way. Let's not imagine that just because we use the term constitutional court in the context of the High Court and the Supreme Court, just because they interpret the Constitution, they are the only ones which have a constitutional role and not the others. The others too have a constitutional role. And the constitutional role given to them is the resolution of disputes. It is the judiciary which has the sole purview of the field of resolving disputes, both between individuals and individuals, and the state and individuals, and because India is a federal country, between governments. So even though broadly most of your disputes are likely to go before a trial court or the high court, all interstate disputes tend to go before the Supreme Court. So if we boil it down, if we strip away all the other jurisdictional issues and so on and so forth, at its core, the function of the judiciary is to resolve disputes between individuals and government, and between government.
Okay, so given that particular definition, right? So some of the things that have happened during the pandemic both seem to make sense and don't seem to make a lot of sense.
Right.
So I think one great example would be the fact that the Supreme Court weighed in and set a price cap on COVID-19 testing and how expensive it should be. Now, how exactly does that work? So I could perhaps think about it as being a dispute between individuals and perhaps private hospitals. But is it within the Supreme Court's purview to set a nationwide price cap? Is that really within its purview? Because I can also see how that would really be the job of the government, right?
It's true. And we have on paper, and when you describe it as such, this shouldn't be what the Supreme Court is doing. But in 2020, we can't unscramble the egg. And let's go back to what happened in the 80s. In the 80s, you had a Supreme Court which expanded the scope of its powers dramatically. The justification offered was that the court, as the guardian of constitutional rights, could not just be limited to old-fashioned disputes and so on, and could give itself a more assertive and expansive role.
It could give itself a more assertive
role. It gave itself, exactly. It gave itself a more, and this is especially the Supreme Court. And it said what holds for the Supreme Court also holds for the high courts. And yes, we have a much more expansive role. Now, this was challenged. And when I say challenged, I mean in terms of discourse-wise by a lot of people saying, how can the court do this? But because the court found a powerful ally in the English-speaking middle classes of this country and the press, most importantly, in its endeavors, it was there to stay. The courts, You could call it interference, you could call it intrusion, you could call it involvement, whatever preferred term that you use, in areas outside the traditional zones of dispute resolution, found a kind of fairly widespread political support. Even the parties which resented the court's intervention when they were in power were happy to approach the court asking for these very wide-ranging interventions when they were out of power. So in that sense, and I can multiply the examples, but the fact is that there was some sort of a consensus. And yes, the parties will crib when they're in power with that, when the court's orders and judgments go against them, that why is the court doing this? But when outside of it, they appreciate this role. Crucially, in government also, there's a sense that if the court wants to take the burden of a difficult decision, let it go ahead. This example of this price fixing is one of those things where I get the sense that if the government had really put its foot down and said, no, we will not tolerate this, we will not allow for this, and we refuse to accept any price fixing by this court, the court would have backed off. There are any number of cases where the government has said, it's going to take us time to pass a law, it's going to take us time to issue the instructions on this, it's going to take time for us to make executive orders. Why don't you fill the gap in the middle? The government has, in fact, ceded a lot of its powers under the constitution in India, especially lawmaking powers. Nothing, when I say government, I mean a mix of both parliament and the executive. Because parliament is by and large controlled by the executive in an India system, nothing prevented the government of India from, say, making a law related to sexual harassment in 1995 or 1996 after the Vishaka guidelines were set out. Yet they took nearly 20 years after the horrific Nirbhaya rape when they finally in 2013 passed the Prevention of Sexual Harassment Act. So in a sense, the governments are, and this is true at both the state and the central level, they see that difficult decisions, if the court takes it out of their hands, they're happy to live by it. If it works, they will say it's because we implemented it. If it didn't work out, they'll say it's too bad, the court shouldn't have been involved. So let's be clear here. It's not always that the court is taking away power from a weak and ineffectual executive. Sometimes it requires two hands to clap. So there is a level of ceding of power, especially in issues which the government would rather not be seen to be taking a decision. That happens all the time. So when we assess what the court has done, it's important to read between the lines. Is this the court asserting its power in the face of executive resistance, right? Executive or legislative resistance? Or is this the court sort of making itself the scapegoat or taking on a burden upon itself because the executive has been happy to hand over the burden to it? So, which is where we should be careful about how we're analyzing the particular order. There are, of course, things the court should not do. I mean, for instance, I can give you the most recent example. The court should not be taking the risk of allowing the Puri Jagannath Rath Yatra to go ahead. Just as with the price fixing, the court is completely ill-equipped. It's completely unable to make sense of whether it's taking the right decision or the wrong decision. It has no legal way of saying this is right or this is wrong. But what it has done, and in both cases, what it has done is that it has taken the glare of the executive. The Odisha government did not take a decision. The central government did not want to be seen to be taking that decision. They quietly supported the court's move in court during arguments. They didn't oppose it or any such thing. But the court has once again allowed itself to be pushed forward, to be seen to be taking a decision when the other two authorities just didn't want to take the risk. So, which is where I think this narrative of the court overreaching or usurping the powers needs to be complicated a little bit more. We need to ask, what was the stance of the government? Was the government happy? Now, there are certain cases where it is genuinely valid that the court and the government are on the same page. I have no issues where, say, for instance, in a matter where it comes to light that the implementation of a government's laws are going awry and the court says we want to monitor it and the government says, sure, we are on the same page as you, we will help you do this better. There are certain cases, like things like running orphanages, things like a midday meal scheme, things like the night shelter schemes. These are all issues where there shouldn't be too much of a divergence between the court and the government on how things are going. And it's just a matter of the court using its processes to hold officials accountable, maybe because the government is failing to do so. And it's a different matter why that government is failing, and maybe we can't look for structural reforms from the court, but if it is in a way of alleviating a problem even temporarily, that might be okay. So which is why when we say the court has overreached in some way, we have to complicate it as to see in what context and in what manner, and what is the government's role in the business.
That's a really interesting point, Alok, and I think you've touched upon a lot of things that I think require a little more unraveling. So let's take them one by one. The first is the very fact that legislatives and executives have been so happy to kind of let the courts take on the glare of public opinion on things that it doesn't really want to be seen doing stuff in. I mean, and this in itself can be problematic because the judiciary is supposed to be strictly independent, supposed to be a strictly independent arbiter of justice, or at least that is how I understand it as an amateur in this field. How is it that this kind of closeness between legislative, or to put more effectively, how is it that this closeness between political interests and the court has come to be? Where did this all originate? When did we start slipping down the slippery slope, as it were?
That's also a long history. But let me sort of point to one very interesting bit of research. And I like to plug it wherever I speak about the judiciary. It's called Jobs for Justice. It was published in 2014 by three authors based in the National University of Singapore, if I'm not mistaken. Madhav Ane, Giovanni Ko, and Shubhankar Gupta. What they showed through very rigorous econometric studies was that as they neared their retirement, Supreme Court judges start delivering more pro-government judgments. Now, those of us who observed the court intuitively felt this, right? I practiced in the Supreme Court for 4.5 years. I've been following it since. If you if you hear from insiders, if you know people who follow the system, they'll tell you intuitively this is what has been happening. But here we have fairly rigorous proof that this is what actually happens in fact. And this is not to say this is a feature of this government or that government. It's a structural problem. My colleague Orgo Sengupta, who in his PhD thesis pointed out how more than nearly 75% of India's retired Supreme Court judges went on to get some kind of a post-government posting, whether it was at the state government or at the union government level. So you do have a problem. And this is unfortunately one of those things where our constitution left it unsaid as to whether, or rather it didn't prevent judges from holding positions given by the government post retirement. Initially, this practice was frowned upon. Let's say it wasn't exactly prohibited or banned, because a lot of the judges, Supreme Court judges, had that standing and respect that when the government appointed them to head a commission of inquiry, people would be, the government genuinely cares about an independent voice speaking about this. Yeah. But at some point that got diluted. At some point, and maybe this is an interesting area for research, at some point it just kept happening so regularly and it became a kind of sinecure. To me, if I have to tap into the most deepest cynical impulses in me, I would say that if you want to really reform India's judiciary, stop them from getting access to the Lachan's bungalows. Those bungalows are amazing. You know, I have seen them. I have worked in them. Those give you the feel of living in like a Roman emperor's mansion. And if you have had that for 5 years as a Supreme Court judge, you will naturally be tempted to extend your tenure in some way that you will get access to this bungalow once again. So the judges who are appointed as tribunal chairpersons, who are appointed, recently to the Rajya Sabha, or appointed elsewhere, they continue to hold their massive Type 8 bungalows, which comes with 2 lawns, 8 rooms, and all this kind of stuff. So there is a structural advantage that the executive and the legislature have had to draw the judiciary closer. But I want to make a deeper point here. And the deeper point has to do with the fact of who gets to be a judge in the first place, especially of the high courts and of the Supreme Court. At the trial court level, it is open competition. You write an exam, you appear for an interview, and if you're good enough, you get to be a judge. That's at the trial court level. At the high court level, you're nominated to be a judge by the existing members of the judiciary and the government. At the high court level, you are either a practicing lawyer or somebody who has served in the district judiciary. Inevitably, the people who become high court judges tend to be drawn from the bar, which is the practicing lawyers, who have had at least 20 years of practice. And given the way our profession is structured, you are likely to be an upper caste, well-off male belonging to a legal family who ends up becoming a high court judge. This description that I just gave, I think you can easily apply it to about 2/3, if not more, of our judges. We have abysmal representation of women. We have abysmal representation of Dalits, Adivasis, and even OBCs for that matter. Any excluded group, abysmal representation in our High Court and the Supreme Court. And it's not accidental. There are structural reasons for it. When you have been somebody who belongs to the more privileged members of the society, you will see issues from the point of view of the privileged members of the society.
Yeah.
A lot of people who get appointed as High Court judges also would have close connects with politicians, because they would have served time as either some sort of government law officer, or they would have been leading practitioners whom politicians would have sought out for advice. So there is a class element to this. There is a small elite of people who become a high court judge, and they tend to think from the point of view of the elite. Not to say every last high court judge thinks like that, but there are exceptions, of course. But when you're talking about this body of men and very few women, you realize they are drawn almost exclusively from an elite, which is likely to share the same worldview as, or probably even more elite worldview as your bureaucrats, as maybe the cabinet ministers, as maybe the elites in the political circle. So you have a system where you share the impulses of the people in power. You see yourself as being close to power, and your outlook and your actions reflect the impulses of those who are in power. So this closeness, I think, is not something to be said for whether this particular court is independent or that particular court is independent. It's when thinking about the judiciary as a whole, about how it self-selects, how it perpetuates a certain kind of old boys club narrative about who gets to be a judge, that makes it so easy for governments to fairly support it.
That's very eloquently put, Alok, and I think you've touched upon something very important here, right? I think very often when the average person, even the average person who follows the news fairly closely, thinks about these institutions, we very often don't think about the fact that there are deeper social networks that underpin the way that all these institutions function. And by definition, when you have a lot of powerful people who, even by virtue of their constitutional, institutional roles, have to consistently interact, consistently have access to the same kind of social spaces, it's almost inevitable that networks of privilege are going to form, especially over generations. And the kind of picture that you sketched out, where the judiciary has kind of progressively granted a larger role to itself, and that political and bureaucratic elites have seen fit to allow the judiciary to kind of take on that larger role for itself, while consistently working to kind of advance their collective interests over decades, I think very elegantly explains the situation that we're in today. That said, I'd like to kind of bring out two further threads here, right? The first is based on an article that you wrote in the print recently about how high courts aren't necessarily functioning the same way. You also touched upon that a little earlier when you said that there are some exceptions to the rule. So can you give us a sense of like how exactly this has come to be? Like, is it really just a question of exceptional individuals, or is there something institutionally different in the way that high courts operate as compared to the Supreme Court?
One important thing to keep in mind is that as a matter of healthy practice, again, it's not in the Constitution, but it's a convention that has evolved in the last, say in the mid-70s, early 80s, is that the Chief Justice of a high court tends to be from outside the state. There's somebody who has no links to the political parties, the elites, and the others of that state. So which means that if they want to stand out, they will have to keep themselves at a distance from these folks. The second thing to keep in mind is that because they're from out of the state, they probably don't have much intention to stay back in that state. So they may not be very keen on a post-judicial posting in that state. Not to say that there are some judges who may not be, but they might be. This has had the salutary effect, not to say that it has had the full effect as intended, but you see that even during the present times, we're seeing that high courts are willing to act more independently than the Supreme Court. Not to say that there have been High Court Chief Justices who have quietly done what the government has wanted them to.
Yeah.
But in a sense, there is the fact that the Chief Justices at least tend to be outside. They tend to be, and for good reason, neutral from any caste or other politics. They may sometimes have a horse in the race, possible, but on an average, they tend not to. Like if you appoint, and as we currently have, a Karnataka judge to Himachal Pradesh, it's not that he'll have much stake in what's been happening there, and vice versa. If you appoint a judge from Maharashtra, as we currently have, to Karnataka, he'll be able to stay fairly neutral and independent and allow himself to stand out from the crowd as a fairly good. And Karnataka has been lucky to have had quite a few of these exceptional chief justices. What they also do is that they shape the court that they are overseeing. You will want to also ensure that the court functions in a way that reflects well on you. So you want to make sure that sensitive matters are listed before seemingly independent judges. You try and give more opportunities to different lawyers to become judges. And, all of that tends to happen. These are the soft underlying trends that, we don't necessarily see, but they tend to happen. But more importantly, you're not at the end of your career. Even as a high court judge, what's the worst that they can do? They can't impeach you because it's too difficult. It's too much in the public eye, and it tends to put people off if you're targeting a judge for a judgment that they delivered. The average high court judge's age is probably 54, 55. If I forget the exact figure, I remember doing the study, which means they have another 8 or 9 years. So which means they are well away from the political cycle. They are in the middle of their careers. They're not towards the end of their careers. They're not looking for a post-retirement sinecure. And by the time you decide the case, even if you want to favor one political party over the other, there's no guarantee that they will be in power by the time you finish your tenure. It'll be very interesting to see if the authors of the previous paper reproduce their models in the High Court and see if we get some concrete material to that effect. I don't think it will, because in as much as even state governments tend to fall more quickly than central governments, they tend to be a lot more unstable. Yeah. So judges also wouldn't like to be seen to be favoring one or the other. Not to say that they aren't, but there is at least a level of separation which is provided by the fact that I'm not retiring anytime soon. I don't want to owe you anything 10 years from now, or I don't want you to owe me anything 10 years from now. I will take my chances with whatever happens then. But I'd prefer to be independent at this point. So there are perhaps some structural reasons why high courts tend to be more independent. Again, as I said, there are always going to be exceptions. But I think the most famous example of what I was talking about was during the emergency. When there were overnight detentions of a lot of political leaders, high courts across the country, almost without exception as far as I can tell, 9 high courts across the country said that even when emergency is imposed, the fundamental right to life and liberty is not suspended, and you can always come to the court if you have been detained unlawfully. But the Supreme Court said no, you don't have any rights left once emergency is declared. You can't go to a court. There's nothing you can do, and we hope the government isn't nasty about this. Right? That's literally what the court said. Interestingly, of the 5 judges of the Supreme Court, you had 4 who said this. You had one famous dissenter, Justice H.R. Khanna. Of the 5 senior judges, all of them were going to become Chief Justice of India. Okay, if the line of succession is to be followed, that is, whoever is a senior most judge after a judge retires becomes the Chief Justice of India, all 5 of them were going to be Chief Justice of India. Khanna dissented, did not get made a Chief Justice. Beg was in favor of the government, was the Chief Justice. Of course, A.N. Ray, who was then the Chief Justice of India, was also on the bench. Y.V. Chandrachud, in favor of the government, was made Chief Justice in 1981, if I'm not mistaken, 81. And Justice Bhagwati also became Chief Justice. So everybody likes to believe that the legal aspect of this ADM Jabalpur case is gone and buried and dead and whatever, right? Nobody is going to say we follow the precedent set down. But I think the more important precedent was in the behavior of the judges and the behavior of the government. The fact that the guy who sort of dissented and stood out was punished, whereas those who towed the government's lines got their quote unquote just rewards, I think that sent out a signal. And I think that continues to plague our judiciary today.
Fascinating. Again, it's just so interesting to me to see how dependent a lot of judgments are on what happens behind the scenes. And so thank you for that, Alok. I think you've given me a very good sense of really what happens, what keeps the clock of the judiciary, as it were, ticking. But before we conclude, I had another broader question that I want to bring your attention to.
Yeah.
You briefly talked about the right to life and liberty and how while the high courts, due to certain structural reasons, were more in favor of saying that, yes, that still stands even during an emergency, while the Supreme Court said that, no, it does not. Today, we're in a situation where there is no declared emergency, and yet the right to life and liberty for anyone who dissents against the government, no matter how peacefully, seems to be under threat. And this is not something that's restricted necessarily to the high courts or Supreme Courts, where he sketched out the structural reasons for why they work the way they do, but also to trial courts, which, as you said earlier in this podcast, tend to be a little more open, tend to be a little more competitive. So what's happened? Has the influence of political parties, of the legislative and the executive, kind of percolated down to that level of the judiciary as well? What really is going on?
There's a near-term and there is a longer-term issue here. The near-term issue, or the more recent-term issue, has been a certain sense that subordinate judiciary is somehow inferior to the high courts and the Supreme Court. In a sense, let's say the high court doesn't report to the Supreme Court, but the subordinate judiciary reports to the high court. And they look to the high court to protect them. Like the high court doesn't need the Supreme Court to protect them. The subordinate judiciary looks to the high court to protect them. When we had a case such as Judge Loya's, and where instead of a full and fair investigation, again, to be clear, if a full and fair investigation said that Judge Loya died because of purely natural causes, I'd be the happiest to find out. But when suspicions were raised, when you said, look, this is a person who was involved in such a high-profile case, took a position which was not liking to the person involved in this high-profile case, suddenly, dies in mysterious circumstances. His family asks for a certain kind of a query. There is this enormous political pressure which comes down saying there is no need for a query. And when the matter goes to the Supreme Court, instead of trying to say, let's find out what actually happened, the Supreme Court itself says this is the official account of what happened. Right? And again, not on the basis of like a detailed investigation, but because the Maharashtra government said this is what happened, okay, the Supreme Court said this is what happened. So can you in good faith question a judge today who feels that, this is a politically sensitive matter. If I take an independent position on this, what will be the consequences? Can I expect the High Court to back me up for having taken an independent position on this? Can I expect the Supreme Court to back me up when I take an independent position on this? This is the near-term factor. This is the sense that can I take the risk of being independent on this? Because let's keep in mind there are about 30 Supreme Court judges and there are 800 High Court judges. No, not 800, 700 High Court judges in this country. But there are thousands upon thousands there are 18, nearly 20,000 district court judges in this country. They work in extremely trying circumstances, and they feel like to them, you need to survive in the system. It's not so much thrive. You need to survive in the system. Which brings me to the long-term point. The long-term point being, when a Supreme Court judge or a High Court judge writes a great judgment, everybody reads about it, talks about it, and says, wonderful, wow, great. Do we do that for a trial court judge who says bail granted? No. Right? We won't even hear about it. Or everyone will be like, why did he grant bail? What was the money behind this? He might have genuinely been a person who said, this person does not need to be kept in custody. I find 10 reasons why bail should be granted. I'm granting bail for these reasons. Set at so-and-so to be at liberty. This is like considered such a mundane aspect of your job that nobody cares whether you do it well or bad. Everyone's question is, did you take money for it or not? Right? And this has created this culture where judges feel that if I'm seen as quote-unquote strict, if I deny bail, I'm seen as upstanding because obviously the state won't bribe me. But if I'm liberal with bail, suspicions will be raised about me. There's a great story, a judge of the Supreme Court. It's a true story. A judge of the Supreme Court told me once, this was after his retirement, when he was in the High Court, They oversee a district and they keep track of how each judge is performing in their district. They had recently elevated a lawyer, a prosecutor, to the position of district and sessions judge in that district. So in his first quote-unquote performance appraisal, the Supreme Court judge said, I want to see this guy's records, bring it to me.
All right.
He found that this guy had acquitted the last 36 accused, like consecutively. So the High Court judge is like, there is no way this is possible. What's going on? So he decides to call him. So he calls him for an interview, not an interview, but as a general, what's up? What is happening? How is it that you have, we thought you were a prosecutor with a good reputation and a firm, independent position and all these things. How is it that you have suddenly acquitted 36 people, different cases, not like in the same case or in the same set of events, 36 different cases, you have acquitted everybody in front of you. What is going on? The judge said, my lord, I'm really sorry if it has upset you, but I know as a prosecutor how police obtain these prosecutions. Therefore, in good conscience, I could not convict any one of them. Okay? So this is a guy who has done his job in the best way possible.
Yeah.
He has brought his experience as a prosecutor not because he thinks from the government's point of view, but because he has applied his mind to it and knows from his experience how things happen. But he will get hauled up, right? It's not, no actual effect may happen to his career. But the fact that somebody will ask you a question if you have acquitted people or are very liberal with bail, than when you're jailing everyone and refusing bail, it creates its own set of perverse incentives.
Yeah.
Right? And this doesn't have to do with the High Court also. I mean, just consider how people approach this question of bail. People consider refusal of bail as basically conviction, and people consider grant of bail basically as acquittal.
Yeah.
There's no sense that these are just temporary measures to ensure that the trial runs smoothly and without effect, and it has nothing to do with their ultimate guilt or otherwise. So there is this larger societal problem that, when we see these issues, everything begins and ends with bail. And given that amount of pressure and focus on the judges who take these calls, they'd rather take the safe call. Nothing protects us. We are not so sure what will happen even if we follow the law and are a bit more liberal. So let us be extremely conservative about it. A High Court judge may be able to take this call because they have all those constitutional protections. We don't, and we're not even sure if they'll apply to us. So there is a tendency for judges to be more conservative about this. When I say conservative, I mean not so much doing their job. I mean, to me, the biggest crime in the custodial deaths of Jayaraj and Benix was the fact that the duty magistrate, right, who is the judge, who is the first judge who's supposed to see any person arrested, didn't even examine them. He stood some 50 feet away from them, asked routine questions from the police, did not see if they were in any physical condition, did not see if they had been beaten, tortured, or any such thing, said, yeah, remand for further police custody. Absolutely did not apply his mind. That is the consequence. And I'm sure it's not because it's only that Jayaraj and Benix died because of it. But I'm sure he did it so routinely in so many cases that nobody asked the question, why are you doing this so routinely? Why are you doing this in such a mechanical way? Surely you should think twice about whether they actually need to be arrested. What is the big crime that they have committed? Why do they need police custody? Clearly, one of them is not able to stand because he's so injured. What has happened to him? Why don't we get a doctor to examine him? What are his injuries? These questions weren't asked at all. But because he has never asked those questions in the context of a regular remand from the police. So which is why this is the larger problem, that judges have been incentivized to work as mechanically as possible. And that is also on the basis of a particular societal expectation that bail is somehow a sign of acquittal and refusal is somehow a sign of guilt.
That's fascinating, Alok. You've basically sketched out this entire system of complex and overlapping incentives, societal push and pull, not just from elite privileged networks, but also from broader societal expectations of how the judiciary should function. And I think I've come out of this with a much clearer understanding of of why the judiciary is the way it is today than I did when I came into this podcast. So thank you so much for that. And to all of our listeners, thank you so much for joining us. Please check out Alok's fascinating podcast, Ganatantra, where he addresses issues of the political economy and the judiciary in great detail and very lucid detail, if I may say so. So thank you so much for breaking this down for me and for our listeners, Alok. Thank you so much for joining us on All Things Policy, and I hope to see you here again.
Absolutely, Anirudh. It was my pleasure. It was great speaking to you.
Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.
I hope you enjoyed that show. I'd like to thank our sponsors this week, Paytm Money and Intel. It's been a really, really cool week on the network. We've had Ashwin Sanghi on Cyrus Says. We have Masaba Gupta on Advertising is Dead. You should definitely check out Vivek Lath, who showed up on Storytellers and Story Sellers. A close friend and partner of ours, Karthik Paricha, was on the Pragati podcast talking about the future of podcasting, which I think is really, really interesting. And I would like to ask people to check out All Things Policy and what they've been doing. They've been having some really interesting discussions about India's challenging relationship with China as we go forward, and I think that would be a great thing for you guys to check out. So with that, we hope to see you again next week.
Hi, my name is Anupam Gupta. I'm B50 on Twitter. I am the host of Paisa Vaisa, the show that talks money. On my show, I speak to experts from every field of money and finance, from stock markets, equities, debt funds, credit cards, life insurance, every possible area of money and finance that you can think of. We even did an episode on cryptocurrency. I've got fantastic guests from mutual funds to personal finance experts everywhere. Robo-advisory, startups, just name it, we've got it. At Paisa Vaisa, we help you make smart decisions about money. You work hard for money. Now make your money work hard for you. New episodes out every Monday, and you can listen to my show on the IVM Podcast app or any other podcasting app that you have.